Welcome to Unencrypted Chatter, the ISC2 New Jersey chapter podcast. I'm Joe Patti, and I'm joined by Michelle Schaap. Michelle, welcome to the podcast.
Thank you so much, Joe.
It's great to have you on. And, I've been looking forward to talking to you because you are not an IT person. We're always talking about how security is more than just bits and bytes and IT. And you're not. You're actually an attorney, right?
Correct. As
Okay.
my children say, I should step away from the computer when it's not operating properly and call the professionals.
Well, can you tell us a little bit about what you do? Because you are in a related field, of course.
Absolutely. And I work with a lot of the technical guys, particularly when we're dealing with a breach response, although I prefer to say incident until we know that it's a
Incident,
breach.
yes.
Correct. But in my side of cybersecurity and privacy, needless to say, as an attorney, I'm dealing with the law and helping my clients understand what laws and regulations they are subject to, what their customers are subject to, because as a service provider, even if you're not directly subject to a particular law, you may be subject to it because your customers have told you you will be subject to it. You also need to consider what your contracts say. So a lot of people don't think about non-disclosure agreements as imposing cybersecurity obligations. Well, if you're not taking reasonable measures, and a lot of the statutes speak to that without defining what it is, and you have a data breach, have you breached your non-disclosure agreement in your contracts? I also help my clients understand what they should be pushing downstream to their vendors, whether they're subject to HIPAA, Gramm-Leach-Bliley, New Jersey's privacy law, New York's SHIELD Act, the DFS regulations for banking or insurance institutions in terms of what reasonable measures they have to have in place. And then, of course, I do incident response and work with forensic resources when incidents do occur.
Okay. Yes, I have had the great pleasure of working with attorneys in incidents before. So, yes, I know that's you need the advice these days, very much so.
And I will tell you the other thing that's important in my role, particularly in those types of events, is a lot of the technical guys are wonderful at digging into what happened. What's the root cause? How do we get the bad actor out of the system? What can we do to shore up the system better? They're not always good at communicating that to their customers. And so often I am the translator between technical speak and our customers, particularly in an incident when they're already pulling their hair out.
Right. Well, it's a high stress situation. That's a lot of the art of it. Um, so, so you're an attorney, and I know that at least in my experience, the cybersecurity, the more legal focus is fairly recent in the world. I mean, I started in cybersecurity in the 90s, and there weren't many lawyers involved. How did you get involved? Brought
So
you into the area?
back in the 90s, when you got involved, I was still in house at Toys R Us. For those who are listening and remember Toys R Us, and Toys was approached by Yahoo, and they said, and we want to put you on this thing called the internet. And of course, that's how people were referring to it back then. And my boss said to me, go figure this out. I said, okay. So I got involved with the internet and the whole concept of e-commerce back in the late 90s when very few people were doing it, let alone attorneys. Fast forward, I went into private practice, and one of our clients came to us and said, I want to go into e-commerce. And I cut and paste everything from the website of Amazon, so that's okay, right? And I said, well, aside from the fact that that's plagiarism, the odds are good that you don't have the same bells and whistles as Amazon. So let's look at what you should have in place. The first laws that came into place were not surprising. California was one of the first. Massachusetts was one of the first. And back in 2004, Massachusetts required businesses that were processing the information of Massachusetts residents to have a written information security program. Nobody understood what that meant and what a written information security program should look like. And so I decided, you know what? I'm going to learn about this. And I dug into it. I've since gone back to school twice for cyber and privacy because when I went to law school, the field didn't exist for coursework, and I'm now an adjunct professor at Fordham in cyber and privacy. And what I love about my classwork is that many of my students are technical people who want to understand the law, and many of my students are attorneys that want to understand technical speak. So I'm still bridging that gap between this is what cybersecurity reasonable measures should look like, and this is what it means to understand what the laws are and what the contracts should look like. And then, of course, vetting the vendors is a huge issue now. And you can't properly vet a vendor without understanding the laws and having the technical side to really kick their tires. It's nice that you ask for a SOC report or you ask if somebody's ISO certified. But if they say yes and you don't know how to dig into that and ask the follow-up questions, you're not doing yourself any favors.
Right. Well, that's always very challenging because, now third-party risk, of course, is a very big thing. You have to do the due diligence. A SOC 2 and some of those other certifications are, table stakes for the most part. But yeah, truly knowing what their security posture, really is day to day can be a big challenge. In my career, I've had things where, situations or someone says, well, it's okay. We'll have a good contract and it protects us. And we say, well, we don't want to sue them. We want them to do it right,
Well, and to your point, so a lot of small businesses are using things like Stripe or Plaid or what have you, or Square to process payments. And they say, well, I'm using Square, so I'm good. I said, well, if you look at the terms of use and the contracts on their websites, the answer is no. First of all, the buck stops with you, literally and figuratively, because you've engaged them. You are the controller under the cyber and privacy laws. You have chosen these vendors. So it's your obligation to make sure that those vendors are PCI DSS compliant, that is payment card industry, data security, systems and standards compliant. And it's not one and done. It's not just, okay, I kicked their tires when I brought them on. You have an obligation to confirm that year after year. But the other thing that a lot of these companies don't realize is A, the Square or the Plaids of the world are not standing behind you. They're not indemnifying you if, God forbid, something happens,
Well, they're
which
not
means,
really.
well, with few exceptions. So I negotiated a contract with one of those payment processors
Mhm.
for a franchise system. When you're doing it for an entire franchise system, you have negotiating power. But if you're the t-shirt vendor, you don't have negotiating power with one of those payment processors. And they're not indemnifying you, which means you better make sure you've got appropriate bells and whistles in place. You better make sure you've kicked their tires and you have your own cyber insurance. Because if, God forbid, one of those payment processors gets breached, you are not the only person with your hand out for that cyber insurance pot of gold, assuming it even covers it.
Yeah, and it's interesting. I mean, I have to think that small, mid-sized businesses, they don't have big IT shops. They certainly don't have a lot of security. The whole concept of knowing what PCI DSS is and some of these things, it's going to be difficult for them to get. I kind of I've always suspected that many of them must think that, oh, by hiring Square or this guy or this, they're effectively outsourcing all that. But I guess not. You still have to have some level of control over that.
Well, and if you don't, and if you haven't vetted those vendors, you will be found liable if, God forbid, something happens. And it used to be that you had cybersecurity laws on the book and not privacy laws, because cybersecurity say, again, reasonable measures in place. Now you have to be able to honor those privacy requests as well, and that requires technology too. Because if you haven't mapped out the data, so let's suppose, Joe, you're one of my customers, and you say, I'm in New Jersey. New Jersey has a privacy law, and it gives you the right to be forgotten. And you say, Michelle, I want to be forgotten. Well, if I can't account for all of your data points in my environment, how do I comply with that request? And if I'm not complying with that request, the Attorney General can come after me with fines.
Yes, well, I know that I've experienced things like that, and I know that from a technical standpoint, finding all that data and having it all classified and labeled is extremely difficult for a lot of organizations, even ones that are decent size because of the great complexity of it. So yeah, the whole data governance thing is that's a really big challenge. I have heard that before too.
Well, and particularly when you're dealing with older companies, oftentimes they'll say, well, I don't want to throw the baby out with the bathwater. So can't you slap something onto my existing environment? And the short answer is no. And it doesn't generally work well. And a lot of companies don't have the budget to reinvent their environment. So it really does become a challenge, which is why the technical side of it is so critical.
Well, it is, and it's interesting. There's the technical expertise, and I know this from my own background. Also, I'm working with people. Even if you're engaging, your attorneys and getting them, but they still can't make all your problems go away. You can't outsource it to them. You need to at least to know how to talk to them, how to ask the questions, and when you say some of these things, know that yes, privacy does apply to you. Yes, you have certain notification obligations and things. You need some level of, if not common language, then at least an appreciation, not to be completely in the dark about things. I mean,
Exactly. And what is good is there are more resources available for education and to learn the language and to learn the technical speak and to also learn the legal speak and also how to communicate. One of the programs that Ken Fishkin has hosted for, I think now several years, is how to speak to the board. And technical folks often get lost in their own weeds. If you can't communicate to a board, you're not going to be able to get budget. And if you can't communicate to a board, this is what happened. This is why we had a data incident. And this is what we need to prevent that from happening again. If all you're doing is throwing out technical jargon, you're going to hit a blank wall.
yes. Well, it's extremely difficult for a lot of people who come from an IT background because it's a classic thing. Can the CISO talk to the board? But I think it's even more challenging than people think, because even if you're a very senior, very seasoned IT manager, the people you're used to dealing with, other managers too, board members think in a totally different way, have a totally different set of things that they're worried about, have a different education typically. And that is really, really challenging.
And is why I think the programs that Ken is offering on speaking is so important for the technical folks to allow them to communicate the technology behind a data breach, the technology behind a properly configured firewall, the technology behind mapping data so that you can respond to a request to be forgotten. I can explain to you what the law is, but you need to have the technological capability to then respond to those requests. And as more and more states adopt privacy laws, we're in New Jersey. New Jersey, finally, 2025, our privacy law is in place and it's effective. And the grace period is going to expire. And if companies aren't prepared to meet that demand, they're going to find themselves being made an example by the Attorney General.
So I've heard that there's a bit of a fallacy out there that a lot of people will try to simplify it and say, when it comes to the privacy law, well, California's got the toughest one, so if we just follow California, we're okay. And I've heard that that's a fallacy, a bad thing to do. Is that correct, or what's the view on that?
Well, it's certainly a good starting point. There's no question, because California is a very robust law. But there are nuances and there's different definitions of what constitutes personal information. And so again, I go back to Massachusetts, which requires a written information security program, and they're quite specific as to what components should be in that program. There are other states' laws that just say reasonable measures. And then you look at Ohio's breach notification law, which says that if you have reasonable measures in place, meaning if you followed an accepted framework or an accepted sectoral law, for example, HIPAA, if you're compliant with that, that could actually be an affirmative defense to a class action suit. And that's really important knowledge to know that if I have mapped not to California, but if I've mapped to HIPAA, if I've mapped to NIST, that's a basis for me to take the position of stuff is going to happen. There's not an if, it's a when I'm going to be compromised. Can you say with a straight face to regulators rather, can you say with a straight face in a courtroom, I took reasonable measures, I took appropriate measures. And in terms of those privacy laws, again, it's not just mapping to California, because California, they're encompassing, for example, employment law as well, or rather employee data. So let's suppose now you're not a customer of mine, you work for me. If you work for me in California and I'm subject to California's law, then I have to protect your information as an employee, not just as a consumer. That's the only state's privacy law that has taken that into place at this time. That doesn't mean that if you've mapped to California, you've covered yourself, not to mention the fact that the thresholds for California are different than, for example, New Jersey. California's threshold is a dollar threshold. New Jersey is a number of residents or consumers threshold. And you need to know those nuances and you need to know when it's going to be enforced. To just say, yes, I've met California isn't necessarily going to be enough. And again, I go back to HIPAA just by way of example. And now certain states, including, for example, Oregon, have adopted their own mini version of HIPAA, saying that if you are processing health information of residents of Oregon, you need to have certain notices on your site. That's different than what California is mandating when you're talking about health information. So mapping to California, depending upon the nature of your business, is not necessarily going to cut the mustard. And of course, everybody, you can't have a conversation without cyber and privacy anymore without talking about AI.
Of
And
course.
what's scary to me is the number of attorneys that still don't get that you can't have ChatGPT write your brief without you checking the citations, because it's still hallucinating and you're still going to get fined by the court. So somebody just fined last week for submitting
Really?
papers. Yes,
That's so known. That's been in the press for a couple years
exactly.
now,
At least
guys, and
2
they're still
years.
doing it? That's
What's worse is expert witnesses are doing it. There was a case, I believe it was out of Arizona, where a law firm hired an expert witness, didn't vet the expert witness properly, and the expert witness used generative AI to create much of its report, which was not correct.
oh, that's not good, obviously. Wow.
And I will tell you, the rules of ethics for attorneys requires that A, you need to use technology where it's appropriate, and B, you need to understand that technology. You can't say, I didn't know when you chose to use ChatGPT to do your research or write your brief.
Well, there's that, and I can tell you also, if I were a client and found out my attorney were just doing that and not checking it. I mean, it's one thing to use it to help for research, to help with the writing, but to say, oh, this was just produced by an AI, and say, well, I could
Oh,
have
and
done
by the
that
way, I just
myself.
billed you $5,000 for the brief that
Exactly. It's
ChatGPT
very
wrote for you,
expensive.
and which, by the way, the court then fined me because it was wrong. Yeah, that's not good.
Well, it's been great talking to you. Thank you so much for joining.
Thank you so much for taking the time to chat with me this evening.
Okay, thank you. And thanks everyone for listening.